Okay, good morning. I'm Jessica Berg. I'm the dean over at the law school, and it is my pleasure to welcome you this morning to our Case Western Reserve University Law Downtown series here at the City Club. Just so you know, we do have one more of these this year. It'll be on December 15th. Professor Hoffman will be speaking on aging with a plan, how a little thought today can vastly improve your tomorrow. This morning's speaker is Peter Gerhart. Peter has been a faculty member at the law school for a considerable amount of time. He's actually one of our deans for about a decade, between 1986 and 1996, and he is currently the interim president at Lake Erie College. We do get to continue to claim him. He is doing some teaching for us, but also continues to do some really fascinating research and work. He'll speak to you today on efficient contextualism. It's an article he wrote actually in contract interpretation. Professor Gerhart is an expert in a wide array of a number of areas of law. He's been working in a number of them, most particularly in torts, but he also does work in international law, antitrust law, and he's most recently been talking about some areas of contract law. It promises to be an extraordinarily interesting discussion about this area, and I'd like to just welcome Professor Gerhart.
Thank you. Thank you, Dean, and so good to see all of you here and to see faces that I recognize and people that I respect. What we're going to talk about today is contract interpretation, the central issue of contract law, and what I want to do is give you a new way of looking at contract interpretation, one that I developed with Professor Kostritsky. This is in preparation for my third book. I have to do a little self-promotion. The first book is Tort Law and Social Morality. The second book is Property Law and Social Morality. And the final book will be Contract Law and Social Morality. And this will be a chapter in that. But I also want to put you to work. So we're going to have the mic moving around because I'd like to hear from you as much as you hear from me. We have something like 55 minutes left, and you'll find some of this talk to be somewhat academic. It's intended to be intensely practical. What we've basically written is a manual for judges as to how to think about contract interpretation in a new way. And I think the new way is important for a number of reasons. So we're entering an old debate, and you know the debate. Should a judge use a textualist approach to contract interpretation or a contextualist approach to contract interpretation? This is, as you know, a lot of people like text because it gives us certainty and forces the parties to specify their obligations, reduces litigation costs. But a lot of other people will think, well, wait a minute, you can't understand the contract without context, and therefore they want to let in usage of trade and course of dealing and a whole lot of evidence. And our first point is this is a very arid and silly debate. It is like less filling tastes great. It is simply not the right terms on which we ought to be discussing contract interpretation. Notice what it does. It says before you interpret the contract, you pick a rule for interpreting the contract. And it's not clear why we need a rule for interpreting the contract when we can just go ahead and interpret the contract. So efficient contextualism simply says, interpret the damn contract. Don't worry about picking a rule to interpret the contract. So our first point is that this debate, and from our standpoint within the academy, scholars write tons of articles about this. Should it be textualist or contextualist? A lot of it, we've read it all, and a lot of it seems to us to be pretty silly. It is a way of making your academic reputation. I don't think it helps the world at all. There is a stalemate in the debate. What we want to do instead in this, what we've done in this article and want to do today is say there's a better way of thinking about interpretation. It doesn't require you to pick a rule before you do the interpretation. It just says do the interpretation. So it's a methodology of thinking about contract interpretation that we recommend that judges apply and that rely on when they negotiate, that doesn't say pick a rule, either text or context, but just go ahead. But this this idea of a way of thinking about interpretation is really driven by a way of understanding how parties bargain, what it is they do, what it is they're trying to accomplish. A view of bargaining that you understand. You know how to bargain, and you know what bargaining is like, and you've been in bargains. For some reason, academics have modeled the bargaining struggle all wrong, and so have courts, by the way. So 3 main points. We want to destroy this fruitless debate between text and context, and we do that by saying sometimes it's text, sometimes it's context, and we're going to have a method of figuring out one from the other. We think there's no rule, you just have a way of thinking, and we think it's important to understand the bargaining context in order to interpret the contract. So we disparage the academic sparring over this. We argue that rules for interpretation are really superfluous. This is part of my general attack on rule-based law. We love the rule of law, but law can't be based upon rules because there are always exceptions to rules, and the exceptions are where law is. So I'm trying to get rid of rules. And as I said before, we're thinking there's a way of deciding interpretation that doesn't require you to decide how to interpret. You just go ahead and do the interpretation. So you can see the nature of the debate, which I've summarized earlier. The problem with textualism, it leads to literalism, which makes easy cases difficult and expensive. And we're going to work on the Hummer case in just 1 second, because I want to hear your reaction to the Hummer case. The problem with contextualism, of course, is that it says anything goes. Bring in as much evidence as you want. Without a way of knowing relevant, context leads to extended trials and high litigation costs. So we want to do away with either text or contextualism and present a way of thinking about what the parties must have had in mind when they negotiated the contract. Now, to get you warmed up into the academic part of the lecture, let me give you the Hummer case, and I want to know how you would decide it. A Hummer, as you know, after the Gulf War, was a very famous vehicle that was then sent on the consumer market, and Hummer signed a contract with a marketing firm that would market the Hummer trademark for use on model cars and hats and T-shirts. If you want a Hummer T-shirt, you could get it through this marketing firm. There was a contract between Hummer and the marketing firm that said this marketing firm, let's call them ABC, ABC has the exclusive right to market the name Hummer on merchandise and that sort of thing. And if Hummer marketed its own name, they would have to pay a 10% royalty to ABC. That's a reasonable contract. It makes a lot of sense. And it's clear what's intended, right? Well, of course, the glitch is Hummer then sold itself to General Motors. And when it sold itself to General Motors, it sold the trademark. So ABC came along and said, well, we get 10% of the proceeds of the sale because you just sold your trademark. And the contract says if you license your trademark, sell your trademark, we get 10%. So textually, literally, ABC should have won. ABC should have charged Hummer, now General Motors, 10% of the, I think they claimed the transaction price of the deal. That's $30 gazillion. So, what's the right outcome? How do we think about whether the license of the trademark from Hummer to General Motors obligated Hummer Motors to pay the 10% royalty that is literally in the agreement? You see the dilemma? What does your instinct tell you? Because there's nothing I'm going to say today that isn't instinctual, that isn't the way your mind already works. Yeah?
The outcome, taking the literal reading, seems absurd given the apparent presumptive intention of the parties.
The outcome seems absurd given the apparent intention of the parties, and that is the normal way of looking at it, and the question is why. Yes.
I think the argument would be that the presumption was Hummer is going to have this firm market its trademark so long as Hummer is a individual going concern, and not when it has already sold its entire company lock, stock, and barrel to a third party. And I think that would be the argument on their behalf.
And why do we think that's the presumption? I can't get away from asking questions. You're absolutely right.
Because Hummer wouldn't have the right then to engage this firm if it is being owned by somebody else.
I assume the contract transferred to General Motors, so General Motors had the obligation to ABC Corporation to pay the 10% if, I don't think the contract died with the transfer of the company, but.
Well, did they pay 10% on the cars?
What?
Did they pay 10% on the cars?
Did
On the cars?
No, the marketing firm. Oh, no. Not on the no. No, you're actually right. Under the original agreement, Hummer did not pay 10% when it sold a car.
GMC is buying the right to sell cars,
Right.
not essentially tchotchkes like cats.
Right.
Extras.
But literally it's buying the name, right? Yeah, no, you're right. You're all right, yes.
If I'm looking for something creative, I don't know if this works. I guess if the intent of if we're looking at what the substance over form
Yep.
is, the purpose of the whole agreement was to sell cars, like the gentleman was saying. So I was thinking when you were asking, if a car is never sold, if a Hummer is never sold, is it right that the firm gets the money? And so what brings, I guess, me to the point is, if later sometime some cars sold because of some of the work they did, that would make sense. They earned it. They deserved it. But to try and get a windfall and say they can make money and they didn't do anything.
But all they were owed under the contract was 10% of the merchandising value that they sold.
Right.
Not the car, right.
But
Well, so I put this to prove my point. The district court said, well, look at the language. General Motors has to pay XYZ company 10% of every time they use the name Hummer. And that because the text said so. And that makes no sense. It's obviously crazy. We're having a little trouble explaining why it's obviously crazy, right? So the first, and we found lots of these cases where district courts get it wrong and it has to go to appeal to a court of appeals. Court of appeals almost always get it right. That is, they find a way to avoid textualism when textualism does not give you the answer that reflects what the parties must have been thinking, which is what you've been telling me. So the question is, how do we know what the parties must have been thinking? What must have been in the contemplation of the parties? Now, as a footnote, I think not on the slide, we want to move away from the word intent, and you'll see this later on. When the parties bargain, they have a joint intent over the terms that are not in dispute. That's what the bargain is. But they have no intent with respect to the terms that are in dispute. So there can't be intent solving this problem. Now, as you know, judges like to say, well, we'll look at the intent of the parties. The intent must have been this. Therefore, we'll interpret it one way rather than the other. We want to move away from the idea of intent toward the idea of what goals did the parties share and how are they trying to solve the goals that they had and what terms did they use. So we think that intent is sometimes a shield for thinking through the problem or for stating a conclusion that it is not really about intent. So this is a little abstract, but all our methodology says is what is the goal of interpretation. Consider the interpretation of each party individually. That is, Hummer says the interpretation only applied to merchandise on behalf of Hummer not the sale of Hummer to General Motors, right? And XYZ Corporation says, no, the interpretation permissible is when Hummer was sold to General Motors, they sold the trademark rights, and we should get a return on that. So start with the fact that they're in different places. And then the methodology says, well, think about what facts must be true in order to reach the goal of interpretation. And therefore, you get down to what facts are relevant to the goal of interpretation. And then you say what facts are relevant to those facts. So it's a methodology of thinking about the deal in which you identify facts that must be true for an interpretation by one of the parties, which is different from the other interpretation, to reach the goal of interpretation. Now, in true academic style, we picked up the label surplus maximizing interpretation as the goal. This is the one economists use, and Juliet Kostritzy is an economist, and I fought with her about lots of this article, but I didn't want to fight with that one. So we used the goal is surplus maximizing, but you don't have to think of it that way. The goal is to achieve the objectives of the parties. Notice I've switched from intent to objectives to reflect the fact that they don't start with an intent, a joint intent. They start with individual intent, and I'll come back to that in a second. But they do start with individual objectives, and they make a deal that meets their individual objectives. And then the key is there are lots of terms that are not in dispute. Given the terms that are not in dispute, what must we believe about the deal they made that allows us to understand how they achieve their individual objectives?
Sell merchandise.
Sell the trademark.
No, sell the merchandise. That's what they both wanted to do.
Sell Hummer?
No, the T-shirts and hats and all this stuff.
And okay, so both parties had that common objective. Okay, so now you've got a goal that is what facts do we have? So the question is, what facts do we have to know in order to know whether the contract, which literally says the General Motors has to pay for the privilege of buying Hummer, has to pay this XYZ. So you're absolutely right, and they had a common. Then therefore you can say they had a common intention, right? They had a common goal, which was to sell T-shirts with the Hummer name on it. And notice that goal is not destroyed when Hummer is transferred to General Motors. That's why the contract goes with the sale. So how do we think about what facts we need to know in order to know whether that goal of selling T-shirts with the Hummer name on it also includes the goal of compensating XYZ when Hummer sells itself to General Motors? And yes, Tim.
Well, this sounds like you need a preamble to a contract. A preamble that would
Yes.
state why the contract is being written in the first place. Sort of like the preamble to the Constitution.
Right. Yeah, but it doesn't. It actually doesn't require a preamble, does it? It only requires an acute understanding of what the parties' individual goals were, what they were trying to achieve.
But without a preamble, you wouldn't know.
Well, can't one infer that from the deal they made?
No, you can't infer what another person's thinking. It's impossible. There has to be a shared agreement somehow.
Well, but you have an agreement. What you don't have is agreement on all the on the implications of the terms used in the agreement.
That's why you need that's why you need to know why the agreement was constructed in the first place.
Yeah, preamble is helpful, but I'm not sure it's necessary because we thought immediately that the purpose was to sell T-shirts with a Hummer name on it and to split the proceeds, right? So if the preamble said that, that would be helpful, but I don't know that we need that. And the more evidence they put into the agreement, the better. But all of these cases arise over situations that were not anticipated at the time of the agreement. Otherwise, they would have had a term covering the dispute. Yes.
I don't think this works. Oh, it does. All right. ABC's is in the business of creating intellectual property and wants to get compensated for the work of its intellectual contribution.
Hummer created the intellectual property. The
I'm
name
sorry.
Hummer. And
sorry.
ABC is what.
But if they're putting on a marketing campaign,
Yeah,
you go to an
they sell it.
advertising firm, they say, okay, for my industry, my creativity, how to get the word out,
Right.
they want to get compensated for getting the word out.
Right.
All right. So that's their objective.
Right.
If they did nothing, they shouldn't get paid. But they did start to do something, and so their objective, I'm just trying to answer this part,
Right.
is for them to be protected for their contribution of promotion,
Yeah.
in layman's terms.
When they license the trademark,
Right.
the Hummer trademark to a shirt manufacturer or
Right.
a TV advertiser.
Because they tied the knot. They
Right.
opened the door.
So we all understand that was the deal that was made.
So that's ABC's objective.
Right. Hummer's objective was to get its name
Get
out.
the word
on
out.
Yeah. So we're right that they have a common objective.
So when you're saying achieve objectives of the parties, but then are they in two different places? I don't
How do we know whether the contract also requires payment on the sale of Hummer to
I
General
was just going
Motors?
to say timing now becomes an issue then.
Uh-huh. And that's fine, and why? That's facts matter.
Well, because now the question is there a fair compensation? Is 10% really fair if they aren't doing much? Because if it gets sold, now we're going to quantify
I'm assuming that
what 10%
I'm
is.
assuming that General Motors is bound by the contract with ABC, that transfers to General Motors. They'll continue to pay the 10% on the merchandising until they renegotiate the contract or steamroll over them somehow. But that's
And that's assuming they keep doing the work, though, for General Motors.
yeah. But yeah, they'll want to. What they wanted was a piece of the price of the sale of Hummer to General Motors. Well, what the article does is just develop a way of thinking about this. That's all this is, a way of thinking about interpretation. And what we would love is if judges said, forget textualism, forget contextualism, here's the best way of thinking about the situation. I'm going to take each person's interpretation, I'm going to take P's the plaintiff's interpretation, and I'm going to ask what facts must be true to fulfill the objective of the twin goals of the parties. And then I'm going to ask, for those facts to be true, what facts must be true? So you set up a decision tree in which you identify the facts that must be true for the interpretation of each party to fulfill the objective of the parties. So you can imagine it like a decision tree. I guess this slide, if a judge said P's interpretation is determined by A and B, that is, P's interpretation fulfills the objectives of the parties if A and B are true. Well, A and B are true if A1 is true, and A1 is true if A11 is true. And it's a kind of a decision tree in which you think through what facts must be true in order to make P's interpretation the one that best meets the deal made by the parties. And that's the core of the argument. And this goes back to the fact that how we term the goal of interpretation is not as important to me as the fact that we know there are terms of the agreement that are not in dispute. We know the situation of the parties before the dispute, and what we're trying to figure out is how did they try to join their goals? What goals did they have in mind to meet together? Given the deal they made. Look at the deal they made and ask what is the interpretation that upholds the deal they made. That would be the surplus maximizing interpretation. So just as part of a review, don't look for the intent of the parties. because there can't be intent when there's a dispute. Look at the interpretation of each party, and you can see how a judge can use this. The judge calls in the party and says, what's your interpretation? Why should I believe that interpretation meets the goals of the parties to this contract? Well, if you tell me why that interpretation meets the goals of the parties to the contract, tell me why I should believe the facts that are necessary to that interpretation. And the Hummer case falls apart pretty quickly when a judge does that. And so do others. And so this just puts it in a different word. What are the determinants of, the factual determinants of one outcome over the other, given the fact that we have to choose between the outcomes? Now, let me run through the famous Reading Pipe case to take you back to law school. Yeah, yes, question?
Yeah, I mean, but just to complete the illustration. So from the Hummer case, what's a fact or two that you think one would look for to determine, whether it supports an interpretation of the
General Motors argues that the contract could not have been written that way if it was contemplated that it would cover the sale of Hummer to General Motors, and that and therefore that has to be excluded from the interpretation. Was not what the parties were trying to achieve. Hummer never would have signed an agreement that would put a barrier between its sale to another company, that would contemplate the sale to another company, and that's what the licensing fee would be. Now, all of those are empirical statements that can be checked, either judicial notice or we can take evidence on some if we need to. The reason we call it efficient contextualism is because if you identify a factual dispute, you can try that dispute. You don't have to try usage of trade and general baloney. Did I answer the question?
I think so. I need to digest that a little bit.
Yeah, but I do too. But so let me repeat it. We know the objectives of the parties were that both Hummer and ABC would make money on the merchandising of the Hummer name. The Hummer's claim is we never would have agreed to an agreement that requires us to pay a percentage of the sale price to General Motors. That simply was not within our contemplation. It wasn't anything we wanted to achieve in the agreement, and therefore the agreement can't cover that. Now, how do we know that? Well, we look at general business practices, and these kinds of agreements are of a specific type, and they're common that they are limited to one seller and one licensing firm. And actually, the argument on the other side is much higher. It's much harder. The ABC argument is, what, we intended to make a lot of money if Hummer sold to General Motors, right? It hardly passes the hee-haw test. Yes.
Well,
except learned counsel wants to say.
Well, from ABC's perspective, we obviously had an interest in revenue that first Hummer and then down the road General Motors would generate from their sales of at least certain things.
The merchandise.
We bargained
Yes.
for that.
Yes.
And part of the reason that we agreed to accept only 10% rather than the 12 or 15 or 18 we might otherwise have demanded is the scope of what that 10% covered.
Good. Thank you, counsel. Now, what facts can you adduce to demonstrate that that would have been within the contemplation of your client at the time? I mean, is this industry practice? And so what we're doing is we're identifying a fact that might be investigated further. That's why we go from A to A1 to A12. So you've got a great argument. Are there any other similar merchandising agreements where?
Yeah, well, so there you're looking right at industry practice, and so right, and I agree. I think that is likely to undermine ABC's position
Claim.
because it seems uncommon.
And our hope is that that'll streamline the case, that the case disappears once you identify the facts that are necessary, and one of the parties says, well, we got nothing more to say. Yes, Chuck.
Aren't the determinative facts that ABC is their only business? The only thing they've done is sell, promoting stuff.
Right.
They don't sell trademarks. They don't sell businesses. So that just looking at the business practice or what business ABC is in, aren't those
Yeah, that would be, yes.
the key
That-
facts?
That would be a determining fact. They had nothing to do with the sale of Hummer to General Motors.
And they never have. In other words, that's
And they
not.
could not have anything to do with that. Yes, David. But David says,
Just to play,
sure.
just to play devil's advocate.
That's why we're here.
Right? I mean, the provision in the contract that kept Hummer paying 10% on anything it did was to undermine or end run
Right.
ABC's economic,
Yes, exactly.
right? So if we change the facts slightly and we said Hummer licensed its name to GM,
Right.
I think we might all feel a little bit differently
Absolutely.
about what would happen under that set of facts. So you could you could argue the next step, I marketed not only my name, but my name and my product and my assets, and I sold them all to General Motors. And if I'm ABC, I could argue you were promoting your name, and I could have negotiated a license agreement with GM, and I didn't because you did, and therefore I should get a percentage
But-
of that.
Could ABC have negotiated a sale of Hummer to GM? Would that have been within the contemplation of, I mean,
Yeah, that's where it starts
ABC
to-
isn't set up to do that sort of thing. So David, you're absolutely right. If Hummer said, General Motors, you use our name on your cars, which is a kind of a license, you'd have a different case than the one we're discussing. I'm not sure it would come out the same way. It would come out differently than we're discussing, but the sale of the business is so completely outside the contemplation of the original licensing agreement.
It would have been interesting to see if you'd taken a slightly different position and said, I'm not asking for 10% of the entire purchase price. I'm asking for 10%
Of the value of the Hummer
Of the
name.
value of the mark.
All right.
Anyway.
So it could have been a too greedy plaintiff. So let's do the Reading pipe.
Did GM win on appeal?
Yeah, yeah, handily, and with easily with lots of sort of snickering, like, and without any need to get around contextual, yes.
Would it have mattered if ABC had done deals like that before?
Yes?
Not because it was an industry standard, but this is the way we do business. So I'm saying, so ABC says, hey, look, as you just said, this is all we do. This is the way we do it, and we can show our track record as to why. So our goal of the contract can be supported very reasonably because this is the way we do business. And so that contract term
And that would clearly be a different case.
is not for a legalism. It's a matter of fact. It's a common sense thing. This is
Right.
how we do business in Amish country. This is how we do business in Rome. This is what we do.
No, that's absolutely right. I mean,
Now, I don't know how much of that came out. The article doesn't really go into what their past dealings were.
no. Well, no, the article assumes that this was simply a trademark merchandising firm.
Promotion thing,
that-
yeah.
that-
Had they done automobile car companies before?
I don't think so. I mean, I think they do general brand merchandising, not automobile companies. And they clearly never sold a company.
Because, and I don't want to change the subject too much, but this kind of reminds me of if you're in the entertainment business and you are an agency that promotes talent.
Right.
There's always those horror stories about the little guy who's the agent gets somebody, discovers them, and they come up with stuff that really starts to send that talent off. But the agreements are very gray about what happens if they leave. They don't have specifics, and yet the person who came up with the theme or how to get this band or artist or whatever or idea or movie concept off the map is left in the dust. But just by pressuring the industry and say, too bad, I'm moving on to a bigger firm. I'm moving on to ICM. I'm moving on to creative artists.
Right.
And is it fair in the same context? Because, hey, but we put you on the map. And
No,
they're just a little guy from Kansas or whatever.
no, it's not fair. But that's a separate problem from the one we're dealing with here. That is, I think we have to separate interpretation of what are the parties' obligations from what's the nature of the bargaining power they exercise, and should we intervene to reform the contract to take into account bargaining power? I like to separate those questions.
I know that's a little off, but I'm just saying maybe where ABC is saying, but this is all we do. And we helped you get this off the ground.
Help you sell to General Motors? Help you build
No,
the
no,
value?
and their ideas of the creativity, what they were going to try and do, that they wanted to be protected for. I don't know.
I don't think so. I think they were just
Greedy.
no. Yeah, I mean, they saw the plain language of the contract. They went to a lawyer. The lawyer said, "Textualism gets us a victory. Let's go for it." And they got through the district court, which is the problem of textualism. So I can do it again now with reading pipe, which is also called Reading pipe. After Reading, Pennsylvania, and this comes from the actual case, which you read in law school. It's a bit of a variation. The buyer said, "I want Reading pipe in my home." And the contract said the contractor would supply Reading pipe. The contractor, because of a mistake, put in generic pipe of the same quality as Reading pipe. So not brand name Reading pipe, but the same thing. There was no lost value because of the change in the pipe. And the buyer said, "Well, you didn't use real Reading pipe, you used generic equivalent Reading pipe. I want you to take the house apart and put new pipe in." So the interpretive issue is, what does Reading pipe mean in that contract? How should we understand the obligations of the parties given the fact that the contract specified Reading pipe? Well, if you look at the buyer's claim, the buyer was going to say the buyer had a preference for genuine Reading pipe, the real trademark, and the contractor either knew of the preference or should have known of the preference. That's the basis of the claim. If the contractor knew or should have known of the preference, then the contractor had an obligation to fulfill that preference. and so we're taking the plaintiff's claim and deciding what must be true for this claim to be plausible. Well, whether the seller knew of this precise preference will depend upon whether the buyer told the seller. I'm not taking any substitute. Or whether the seller should have known from the experience in the trade that buyers like real Reading pipe and don't take generic equivalents. So you can see what we're doing is we're starting with a claim and then identifying the facts that must be true for that claim to be true. If the buyer should have known, it's because the seller should have known from experience that people in this part of Pennsylvania just think Reading pipe is. So you can plug in your factual scenarios. If the buyer's brother-in-law ran Reading pipe and they specified Reading pipe, then chances are that's what the obligation was. There's a reason to specify Reading pipe as opposed to use Reading pipe as a generic for a kind of pipe. The seller's interpretation is buyers generally, this buyer and buyers generally do not have a preference for Reading pipe. They don't normally pick the kind of pipe they have. They may want a quality of pipe, and Reading might be a good proxy for a quality of pipe, but from all the experience of the seller, Reading pipe means get the best pipe you can of that grade as cheaply as possible. And that the seller could not have known about the preference and had no obligation to ask. So you can see how we've taken the argument about one interpretation and tried to peel away what facts must be true in order for that interpretation to be accepted. Then you try the facts that are relevant. Any discussion of Reading pipe? That is, if you start with the presumption that homeowners want pipe of a certain quality, not of a certain brand, we normally leave it up to the architect and contractor. Tim says that's not right.
People buy brands all the time. They just want the brand, even though another product is less expensive.
I don't disagree with that. That's an empirical claim. Wouldn't a buyer who wants a particular brand of pipe, we're talking about a pipe that goes on the inside of the house, not an awning or a light fixture. If they had that preference, wouldn't they make that known?
Well,
To-
didn't the contract state Reading pipe?
Yes, it did.
Well, that seems like they made it known.
How do we, oh,
Well, and your fact goes to that argument too, because if most buyers say, we don't care, we just care about the quality, this guy didn't say that. He said, I want this kind.
that's the debate, yes.
But is Reading pipe known just for being Reading pipe, or is it known as that quality, like Kleenex? I say
Yes.
Kleenex, and I don't care whether it's Puffs or Kleenex.
That is the argument. Some people do. And if Larry wants, if Perry if Larry wants Puffs over Kleenex, he'll say, I want Puffs, right? No, I mean, that is the hub of the argument. But
It's a case about damages, not about interpretation.
no, we changed the facts a little bit. The actual Cardozo wrote the case so that it was about whether you have to tear down the house in order to replace the pipe when there was an honest, reasonable mistake. So you're all understanding the nature of the debate, which is what is normal for people to specify in terms of the nature of the pipe they need, and do they have an obligation to tell that they've got an idiosyncratic preference.
So you're assuming this is really a reasonable man's standard, you're assuming.
All law is a reasonable man's standard. That's what social justice is. Yes. Maybe I was too flippant. I'm assuming I'm assuming that that humans behave reasonably, and that we can recognize when they behave unreasonably, and we can therefore make decisions, including decisions about interpretation based upon
Once the
some
quality
presumptions.
changes, is that
It's
a
a
valid assumption?
it's a provable fact. That is. No, yeah, you're absolutely right. As meaning changes, contract interpretation will change. The meaning of a particular contract can't change because that meaning was frozen. But the next Reading pipe contract may well be interpreted differently if the meaning of Reading pipe has changed. Yes.
Well, at risk of seeming provocative, isn't the decision tree of facts and sub-facts arguably contextualism by another name?
Oh, it is. It's just, it absolutely is, and it's okay to be provocative. It certainly avoids over-trying textualist cases. Our claim is that by identifying facts that must be true for other facts to be true, we can streamline contextualism. So rather than saying, what's the usage of trade, we're really saying, what do we need to know in order to get to this interpretation? So the claim is, unproven, but the claim is that once you go through this decision tree, you get to a dispute about how people view the name Reading pipe when they buy homes. Then you're only trying that dispute. You're not trying everything else. You're not throwing in the kitchen sink. So our claim is that a judge using this method can say, well, here's the issue to be tried. Here's what I need to know to decide the case. But as far as I know, no judge has used this.
Yeah.
Right, yet, right. And this is the message to the courts. What makes your interpretation surplus maximized? And they're not likely to say that. They're likely to say what makes your interpretation achieve the separate goals of the parties that they must have been contemplating, which then becomes the intention of the parties. We hope courts can narrow the issues by determining what empirical claims need to be tried, are being made, and need to be tried. And then if there's a value issue, like do we want buyers to specify the kind of pipe they want because we want them to take responsibility for their purchases, you can break a tie on that basis. That is, there is a sense in which the law is incorporating values. And that's our example. In some cases, the law will want to put the burden on the buyer to protect himself or herself because that's the entity most likely to reduce misunderstandings and costs. Yes?
Sounds like in the last frame, your methodology is a great framework for mediation.
Yes.
Not necessarily a trial, but if people are coming together, following your methodology is an excellent framework
For mediator, yes. Yes, because all our methodology says is there's a way of thinking about this problem.
Because that's what you're trying to do, is get people to open up and talk instead of fight.
Right.
And say, well, what's your going?
So I should get a licensing fee every time there's a mediator. Right? No, I thank you. I appreciate that. Yeah, and as I said at the beginning, this is not something you do this every day. You think like this every day. We're just trying to make explicit a method of thinking that people use.
Have you used a drawing board when you do this?
Yes. Yes.
Because I use a pad. I sit down at the table and I say, let's draw some pictures.
Right, when you're a mediator.
No, when I'm not. Just
Oh, you're not, no.
Parties, if no mediation, I just do that anyway because I help people look at it.
Yeah. So I don't have the PowerPoint skill to show you the decision tree in the way it would be, but it's there. It's clearly there. And it's a systematic way of thinking about the case. Well, you don't want to hear other examples. I want to say a little bit about our view of the bargaining model, because I think our position is somewhat different than many other in academia, maybe not from the position in this room, and clarifies and grounds some of the other things we're going to say about contracts, not just interpretation. But when you think of parties bargaining, they come with their private projects. They don't come with joint projects. And they have different attitudes towards risk and uncertainty, and great uncertainty about the other party. So, and then each party achieves its private projects by giving away as little as possible to get as much as possible. So it's the struggle of how do you get a common project out of disparate private projects that makes the bargaining process so fraught with danger and often fail. And that means each party is seeking to minimize negotiating costs, interpretation costs, cost of counterparty non-performance. That is, each party is trying to minimize its cost of renegotiating the contract or enforcing the contract. And now we're being academic again. What this means is there's no, and you know this, there's no unique solution to a bargaining problem. There's no unique solution when parties sit down to bargain. There are lots of solutions that they could reach. Each of them is efficient. There's no one. Julia let me slip this in without understanding that this means there's no surplus maximizing goal of the parties. There's no one unique outcome. It is about the trade-offs that the parties are made. So the goal is not to say how would a hypothetical reasonable person bargain, or what's the most likely outcome for this kind of a bargain. The goal is actually identify what happened in the bargain. What is it that one person traded off to get something else? And that's why in our methodology we say look at the terms that are not in dispute. That frames the whole thing, because that tells you where they agreed. And what we have to find out is how do we understand the nature of the obligations where we now know they did not agree. So this is an important academic point because so many economists think there's a unique, efficient equilibrium. And there simply is not. The law and economics movement is at a dead end because it can't tell you what equilibria are efficient. So our conclusions are the parties want to move forward with exchange. They don't want the perfect contract. They will not bargain. They will not spend more time bargaining than the time is worth. The trade-offs they make are unpredictable and interdependent. I will do this if you do that. even though I don't want to do either. Each party can reduce interpretive risk by continuing to negotiate, but parties don't bargain over a rule of interpretation. What parties want, in fact, we think, is for the rule of interpretation to be the methodology that we introduce. They want courts to look at the bargain they made and interpret it in light of the way they achieve joint benefits from separate projects, from private projects, and the way they must have made the trade-offs in order to, which is another way of saying that if this goes to a part of the academic literature that you don't even care about, but it's in the paper. If parties wanted to pick a methodology of interpretation, they would pick ours, because ours says do the right thing. And they wouldn't say, no party's going to say this contract must be interpreted literally, because they don't know whether that'll be for them or against them. Or they don't want to say this contract will be interpreted using using context, because they don't know what that means. So there's a string in the literature that says let the parties choose, and our argument is no, parties ought to depend upon courts to use the methodology to get it right, because that's what minimizes the costs of bargaining.
Yeah, although parties do bargain over certain interpretative features or aspects, they bargain over choice of law, they bargain over whether the headings, should be construed to determine the meaning of the provisions. They bargain over whether the language should be strictly construed against one or the other. So there are certain interpretive features that they do bargain over routinely.
And so two comments. One is clearly parties bargain over the meaning of terms. So they specify to the extent they're willing to invest in bargaining over the meaning of terms. As to the ones you mentioned, do those things really matter? I know lawyers do it. They do choice of law, and they have internal rules of interpretation, and some of them are taken from form books. Do they? And I don't know the answer to this. And so I absolutely agree with you that the parties are in control of the bargain. The parties are in control of, and that's the whole idea of this. What did the parties decide? And some contracts say that courts should use text to construe this. Strictly construe the words used in the contract. But I don't think a court's going to listen to that if it's not the right thing. But I don't know. That chapter's not yet written. Well, let's have questions now. And I appreciate the discussion and the feedback. Yes, David.
So how do you get courts to adopt this?
Well,
It would be very difficult that they're so entrenched in historical contract interpretation that you're asking them to do something with no historic precedent. Not that they shouldn't, but I just
no,
mean,
I understand. I understand, and that's something I've thought about, because part of the article is written for other law professors, but its real importance would be if are there any judges here? So the question is, how do we, and I've asked some judges, and I don't have a good answer yet, how do we, where do judges go to school to get new ideas or to think differently? Because all you have to tell a judge is get the parties in your courtroom and say, what's your interpretation and what are the facts that support your interpretation. If once a judge does that, the case takes on a much different. So I have not yet been invited to judges' school. So we need to write a version of this for the National Law Journal or whatever judges read. They don't read law reviews. Yes, Chuck.
You mentioned the subtitle of your books, social justice or something like that, but you haven't mentioned how social justice applies to this interpretation.
Social justice is simply be reasonable.
Okay.
So it's all. Tim picked up on this. All about the law is using the reasonable person standard to determine how it is shaped and what obligations people ought to have. So there is a philosophical theory behind social justice that has to do with the veil of ignorance and making decisions behind the veil of ignorance. And but basically, it comes down to the law says be reasonable.
It's not political correctness.
It's not political correctness. No, because I'm only dealing with disputes between individuals. I'm not dealing with disputes between the state and individuals. No, there's no political correctness. Well, people will be confused. So social justice writ broadly is not my interest. It's how we treat each other, right? The books are about how we treat each other and how the law shapes how we treat each other.
Because you can't interpret your contracts without understanding social justice.
No, but the social justice implies equal rights, non-discrimination, alleviating poverty. None of that has to do with the interpersonal conflicts that I'm dealing with. And, I mean, in property law, you trespass on Bill Gates' property, you can't say, well, he's rich and I'm poor. You trespass. So there's no social justice writ large in property law or in torts.
Yes, but if you read novels of post-colonialism, you'll find that concept is sort of disappearing, that people can trespass on very rich people's property with impunity because they don't deserve that property, or they obtain that property in an illegal way or
that's true,
socially unjust way.
So
that's changing.
No, that's
or it
true,
could
but it's changing in the context of interpersonal relationships. That is, the relationships between owner and non-owner are changing, but those are relationships between individuals. And I think I have to let the audience go. No, but thank you very much. It's been great to be with you and hear your ideas.